May it please your lordship. My lord, we don't have to go through the Rule 5, which my learned friend already has pointed out before this court, which we made in 2021. The entire is a very narrow campus. Whether there can be any classification or not in view of the presidential order of 1950. That's what the case is about. If we can't make, that's the end of the matter. That's the end of the matter. You don't have to go to the other part which we said class 11, 12, because first your lordship has to look into the classification. Which the state has made this classification. Because my learned friend, your recalls, I will not go through these papers, my lord. I'll just point out. 2016, we made the rules. My learned friend read the rules of 2016, which was put to challenge before division bench in PI. And my learned friend has read certain few paragraphs stating that the learned division bench relied on the judgment of the Supreme Court of 2005, E.B. Chennai's case, that there cannot be a classification which you are making. So the state has made a rule which is classified. There cannot be a sub-classification or micro-classification as rendered by the Supreme Court in E.B. Chennai's case. So how can you make classification? So if you make classification, you can't make, it's bad in law. So on the basis of that, 2016 rule was set aside. We further pointed out before the court in 2019 when this matter was decided by the division bench, relying on the E.B. Chennai's case, that why we made this classification. The percentage we have shown for the last 5 years. Court said don't show this percentage for the last 5 years because you have classified. So the main subject is if you cannot classify, then those points goes. Classification will not work out, which you have shown or chart to us. So the division bench relies on the judgment of E.B. Chennai and said that your rule is violative of Article 14 and it is set aside and make a new rule. So 2021, we made a rule, my lord. Again, in this 2021 rule, if your lordship looks into it, there is a classification which we made. My learned friend says, how can you make classification? Whatever rules you framed in 2016 rule is a repetition. It's a repetition of 2016 rule which we made in 2021. Again, you made the same mistake of E.B. Chennai judgment which was relied. That's the whole case, my lord. Now I will submit before lordship that there is nothing wrong which the state has made for further classification. My learned friend has shown the constitutional provision of 342. My learned friend has not read that after 342, there is an amendment insertion of the constitution in 342A.
In 2018.
In 2018. E.B. Chennai is in 2000, my lord, 2005. Constitutional amendment, your lordship will kindly see in 2018. So, all the judgment of E.B. Chennai, there was no constitutional amendment. My learned friend read 342 only. Kindly see the constitutional provision of 342A. And I will say with great respect, this is a better judgment because of the constitutional amendment of Devinder Singh judgment, my lord. Kindly see 342A. Kindly see, my lord.
We are concerned with 3.
We are concerned with 342A3, my lord. Lordship got it, my lord. 342 is the scheduled tribes. 342A, my lord. Lordship got it. 8. Please go down below. Please go down below. It is insertion of by the constitution in with effect from 11/8/2018. Lordship got it. Your lordship, if your lordship goes down below, see the insertion which has been made in 11/8/2018. 342A. My lord, footnote. Your lordship got it. Now kindly see 342A3, my lord. We are concerned about 342A. Lordship got it. 342A3. Notwithstanding anything contained in clause 1 and 2, every state, notwithstanding anything contained in clause 1 and 2, which is the parliament, my lord, 1 and 2, every state or union territory may by law prepare and maintain for its own purpose a list of socially and educationally backward classes entries which may be different from the central list. So the power has been given to the state by way of insertion of 342A, and which our case falls in 342A3. So this power has been given to the state, and accordingly state can definitely classify. They have to look into it, a list of socially and educational backward classes. So, my lord, this judgment, this 342A has been interpreted by a judgment of the apex court. Strength of the E.V. Chennai 5 judges is same by Devinder Singh, that is 5 judges. They respectfully differs. They said if Devinder said the E.V. Chennai should be revisited because of there is a constitutional amendment
and
subsequent development which has taken place. So my learned friend said one judgment of the apex court shown when it is shown for FNI show that judgment is completely on a different footing. How when the matter came up, E.V. Chennai, the subject matter was the same in Devinder Singh. Kindly see Devinder Singh judgment, my lord. I have given this copies, my lord, before your lord. I think that's the issue where before this court also. Kindly see, my lord will keep in mind, please, my lord, 342A, E.V. Chennai, at the time when it was decided, 342A was not there, my lord. 342A3 was not there. 342A itself was not there when E.V. Chennai was decided. Now kindly see 35, my lord. Para 35. Kindly see the strength of this judgment, my lord, of Devinder Singh is 5 judges. Kindly see 5 judges. Your lordship will kindly note down. Same as Chennai, 5 judges. 5. Now kindly see 35. That question, para 35. The question 35 is the question arising for consideration is whether subclassification made of preferential treatment within the class of scheduled class, scheduled tribe and socially and educationally backward classes can be said to be an exercise of inclusion or exclusion, particularly when the other caste in the list of scheduled caste persons are not deprived of the benefit of reservation in totality. All the cases included in the list of scheduled caste are given the benefit of reservation as per representation in service, but only specific percentage fixed for preferential treatment to a caste class which are not able to enjoy the benefit of reservation on account of their being more backward within the backward class of scheduled caste. The preferential treatment would not tantamount to excluding other classes as total deprivation caused to any of the caste in the list of scheduled caste under Article 342(1). Caste is nothing but a class. It is a case of classification to provide benefit to all and to those deprived of the benefit of reservation being the poorest of the poor. Whether the action based on intelligible differential to trickle down the benefit can be said to be violative of Article 14 and 16 of the Constitution, and whether subclassification can be said to be an act of inclusion or exclusion, particularly when various reports indicating that there is inequality inter se various castes included within the list of scheduled caste. They do not constitute homogeneous class having been relied upon based on the report and to give adequate representation to those who continue to remain the most backward of the downtrodden class. The provisions containing a certain percent or preferential treatment subject to availability without depriving others in the list were made. So now if your lordship further goes, this was the issue before your lordship, before the court, 5 judges, whether there can be a subclassification or not among the scheduled tribes and whether the state is empowered to do it or not. So if my learned friend's submission and E.V. Chennai's submission is, my lord, taken into consideration, then subclassification, there cannot be a subclassification. But in view of the amendment, insertion of the constitutional amendment in 342A3, that subclassification, that classification has been given to the state. So that point was this. That was the point before the 5 judges. So now, my lord, kindly see how it is discussed. What the apex court 47 kindly be seen, my lord. 47. The Constitution is an effective tool of social transformation, removal of inequalities, intends to wipe up tears from every eye. The social realities cannot be ignored and overlooked, while the Constitution aims at the comprehensive removal of the disparity. The very purpose of providing reservation is to take care of disparities. The Constitution takes care of inequalities. There are unequals within the list of scheduled castes, scheduled tribes, and socially and educational backward classes. Various reports indicate that scheduled caste and scheduled tribe do not constitute a homogeneous group. The inspiration of equal treatment of the lowest strata to whom the fruits of reservation have not effectively reached remains a dream. At the same time, various castes by the laws remains where they were, and they remain unequals. Are they destined to carry the backwards till eternity? Now kindly see 49. Providing a percentage of reservation within permissible limit is within the power of the state legislature. It cannot be deprived of its concomitant power to make reasonable classification within the particular classes of scheduled caste, scheduled tribe, and socially and educationally backward classes without depriving others in the list. To achieve the real purpose of reservation within constitutional dynamics, needy can always be given benefits. Otherwise, it would mean the inequality is being perpetuated within the class if preferential classification is not made, ensuring benefit to all.
Now 51 is important.
Now kindly see 51. 51 is important. The scheduled caste, as per presidential list, are not frozen. Lordship got it, my lord? If you argue on 342, it is frozen. Now here judges, 5 judges says 51. The scheduled caste as per presidential list are not frozen for all the time, and neither they are homogeneous group, as evident from the vast anthropological and statistical data collected by various commissions. The state law of preferential treatment to a limited extent does not amend the list. It adopts the list as it is. The state law intends to provide reservation for all scheduled castes in a pragmatic manner based on statistical data. It distributes the benefit of reservation based on need of each scheduled caste. It is same. The statistical data was not considered. It was same in 2019. Because why, my lord? My statistical data, which was given in 2019, that was not considered because of 2020. That judgment, EV Chennai judgment still holds good, because 2020 only this judgment came into effect. But 2019, when I showed the data, that data was not taken into consideration by learned court, because where is the question of a classification? There cannot be a sub-classification in EV Chennai's case. That was made very clear. We give a data, statistical data. Here also we have annexed that data. I'll show it, my lord. We have annexed the data. What is the percentage of the Chakmas or non-Mizo ST? Ultimately, it boils down to 2 seats for the last 5 years. I will show it. All these seats will remain vacant. So we have given a data. That time, in 2019, when the court looked into it, court said, how can we look into it? We cannot look into your data because of EV Chennai's case. Now kindly see the judgment, 2020 judgment. This paragraph, that's why I read paragraph 51. It doesn't get frozen at all. So it is on the state. That's why 51 is very clear, my lord. And 48, my lord, talks about the state part. 48 talks about the state part. 48. Now kindly see how the court, 58, now kindly see the last paragraph. 58, kindly look into it, my lord. We endorse the opinion of a bench of 3 judges that EV Chennai is required to be revisited by a larger bench. More so, in view of further development and amendment of the Constitution. Lordship, now kindly see amendment of the Constitution of 2018, which have taken place. We cannot revisit EV Chennai being bench of coordinate strength. We request the Honorable Chief Justice to place the matter before a bench comprising of 7 judges or more as considered applicable. Now, how, your lordship, can your lordship now rely on EV Chennai's case? 1, there is an amendment to it, 342A3, which empowers the state. That was precisely Devendra Singh in last paragraph says, sorry, we can't, it has to be revisited. Let it place before the learned Chief Justice. And whatever Chennai has, my lord, there cannot be any statistical data in view of Chennai's case, because there cannot be any classification. There is a question of relying on statistical data. So, my lord, this matter, now what I have gathered, that this matter has to be placed by Chief Justice. It has been placed, but there is no, the larger bench has not been constituted to decide the issue in view of the constitutional amendment. Now, what I found, my lord, exactly on a similar situation in Patna and High Court, division bench, the issue was propped up, same, my lord, same issue has propped up. Kindly see how they dealt a division bench of Patna High Court. Same issue, classification. How it was dealt, both the matter, both the judgment was placed, and how the Patna High Court dealt it. That's the Chief Justice or normal Justice S. Kumar, my lord. Now I think the Chief Justice, with great respect, is in Apex Court, my Supreme Court, my lord. Same Chief Justice, Justice Punazil Karol, my lord. My lord will kindly see this order is of 3/9/2020. Lordship, kindly note down 3/9/2020. Kindly see the prayer. Next page, my lord. Prayer 1. That the unconstitutional impugned resolution dated 30/8/2017, bearing memo number 2950, issued by Government of Bihar without following the mandatory provision under Article 338(9) of the Indian Constitution contained in Annexure 10, and its all subsequent recommendation may kindly be finally set aside. Because, my lord will note down, because it is unconstitutional and violative of Presidential Order of Government of India 1950. And by this impugned resolution, the Bihar government has constituted a Rajya Mahadalit Ayog, making micro-classification of scheduled caste of Bihar state. Lordship got it, my lord? This is the same. Now kindly see, this was the issue. Now, how the court at next page, my lord, kindly see next page. In support of this his contention, Learned Counsel for the petitioner invites our attention to the decision rendered by Honorable Apex Court in 2005, 1 SS 394, titled as E.V. Chennai versus State of Andhra Pradesh. In opposition of the petition, Sri Pavan Kumar, Learned Counsel appearing for the state, invites our attention to the most recent constitutional bench 5-judge decision dated 27/8/2020 of the Honorable Apex Court in civil appeal number so and so, State of Punjab versus Devinder Singh. We find that the latest constitutional bench, also same judge strength, has differed with the view taken in E.V. Chennai's case. In fact, they had gone to the extent of holding that it is permissible for the state to identify and confer benefits to the certain person on the basis of social and economic disparity. However, we find that only to maintain judicial discipline, the matter was referred to larger bench for revisiting the decision rendered in E.V. Chennai's case, Supra. We notice that the instant petition was filed on 25/2/2020 and no interim order was passed in favor of the petition. The action of the state stands implemented to the marginalized and economically backward person among the scheduled caste. In that view of the matter, we are of the considered view that the present petition can be disposed of on the following terms. Parties shall be bound by the outcome of decision rendered by the larger bench of the Honorable Supreme Court of India. Reference thereof is made in State of Punjab versus Devinder Singh. Petitioner can approach this court on the same and subsequent cause of action if need so arises subsequent to the said decision. So, my lord, the entire petition was disposed of on the ground that judicial discipline propriety should be maintained. So, let it be decided by the Apex Court. Thereafter, the matter can be taken up. So, that's the view. And normally, my lord, your lordship also normally maintains a judicial discipline and consistency are being maintained, which in Supreme Court in 1960 also said one has to maintain. Unless you can distinguish both. Here, my lord, your lordship is in subject matter is the same. Is a classification, sub-classification, micro-classification, whether it can be made or not. So, if it can be distinguished, yes. But if the subject matter is the same, because the crust of the empire matter is the sub-classification, micro-classification. And my lord will kindly see, I think Devinder Singh judgment of 2020 is based on 2018 the constitutional amendment, insertion of the amendment. And 342(2) and the statistical data. Now, if your lordship kindly look into it, 360, I think one judgment of the Supreme Court, this only. Para 19, kindly see, my lord. Para 19 of the Apex Court judgment, 1960, Supreme Court 936. I have given. AR 1960, Supreme Court 936. Kindly see 19, my lord. Three judges. Para 19. Before we part, lordship got it? Yes. Before we part with this appeal, however, it is our duty to refer to one incidental matter. We have noticed with some regret when the earlier decision of two judges of the same High Court in Deo Ranjan's case was cited before the learned judge who heard the present appeal, they took on themselves to say that the previous decision was wrong instead of following the usual procedure in case of difference of opinion with an earlier decision or of referring the question to a larger bench. Judicial decorum, no less than legal propriety, form the basis of judicial procedure. If one thing is more necessary in law than any other thing, it is the quality of certainty. The quality would totally disappear if judges of coordinate jurisdiction in a high court start overruling one another decision. If one division bench of a high court is unable to distinguish a previous decision of another division bench and holding the view that the earlier decision is wrong itself gives effect to that, view, the result would be utter confusion. The position would be equally bad where a judge sitting singly in the High Court is of the opinion that the previous decision of another single judge on a question of law is wrong and gives effect to that view instead of referring the matter to a larger bench. In such a case, lawyers would not know how to advise their clients, and all courts subordinate to the High Court would find themselves in an embarrassing position of having to choose between disentitlement judgments of their own High Court. So rightly, my lord, I think the Patna High Court has observed that when the Ivichanna judgment has been referred, so I think we should wait till the judgment is being passed.
What do you say about this?
Now I will show. Now before that, my lord, I'll show the judgment of my learned friend which is cited. Before that, I will show the judgment of the court at page 71, which my learned friend has referred to this writ petition to PL, sorry, my lord, PIL, my lord. 71. I am not troubled with the judgment. My learned friend has read paragraph 17, which was a crust of the issue at 17, because your lordship kindly see 17, my lord. Once again, 17. And when the question that arises for consideration is whether for the purpose allotment of seat categorization as contemplated in category 1 and 2 could have been legally made. That was the, my lord, issue before the division bench.
And only decision on that issue.
So on the decision of the issue of a classification, whether you can make a classification among the ST, that was the issue before the court. The facts in Ivichanna were that the state of Andhra Pradesh appointed a commission to identify the groups among the scheduled castes found in the list prepared by presidents under Article 341 of the Constitution would have failed to secure the benefit of reservation provided for scheduled castes in the state in a manner of admission to professional colleges, admission to professional colleges and appointment to service in the state. So that was the issue, my lord, before the division bench. Now, my lord, will, if your lordship kindly see at page 71, from the third line from top, at page 71, lordship got it? The objective of classification under Rule 5 is stated to be to reserve percentage of seat for the purpose of admission in higher educational institution. If that be the objective, the scheduled tribes who figure in the Constitutional Scheduled Tribes Order 1950 and who are permanent resident of state of Mizoram could not have been placed in two different categories of permanent residents. So if the Presidential Order of 1950 says that there cannot be any classification, how you classify? You cannot classify. Now, any attempt, now further your lordship, any attempt to differentiate the member of scheduled tribes who figure in the presidential list under the Constitutional Scheduled Tribes Order 1950 by any parameter such as permanent residency, etc., would amount to fiddling and tinkering with the presidential list, which is not permissible in law. Absolutely correct. My lord, 1950 presidential, you cannot tinker with the presidential list. How can you tinker? Till 2018. But 2018, my lord, there was a change.
It's no longer a frozen list.
So it's no longer a frozen list. Lordship has seen the judgment of Devendra Singh. Is no longer a frozen list. Why? Because of the 342A and 3. Now kindly see further what the learned division bench with great respect have said. Benefit of reservation has to be uniformly applied to all the scheduled tribes listed under the Constitutional Scheduled Tribes Order 1950. And it cannot be countenanced that one tribe would get higher percent of reservation, another lower. In that backdrop, now kindly see, in that backdrop, the basis of categorization whether it was on the basis of performance in STEE for the last 5 years or on the basis of appearance of student in STEE in the last 5 years carries no significance. So my statistical data, which was given, my lord, that court said we will not consider that statistical data. The basic foundation is the classification. You cannot make it. You cannot tinker with the 1950 presidential order. Where is a question of giving that list? So what is our data? Kindly see, my lord. Now, if Devendra Singh judgment, my lord, it is held by a larger bench that yes, it is a prerogative of the state because of 342A3. Then my data, my lord, my data has to be taken into consideration, my lord. What data I have given, kindly look into it by affidavit. So, my lord, the affidavit by the state in the writ petition, 285. Lordship got it, my lord? The affidavit, 285 of 2020.
Is it by Joint Director?
Yes, it is joint director.
Higher and Technical.
Lordship got it? Joint director? Lordship. Kindly see page 12, my lord. No, kindly see page 11, 8.7. 8.7. If you rely, my lord, 342A3, this data was given basis of 342A3 subsequently, my lord. Kindly see 8.7. It is pertinent to note that almost the entire population of state of Mizoram consists of scheduled tribes and majority population belong to geo-ethnic scheduled tribe, that is Mizo ST. In fact, the Higher and Technical Education Department, Government of Mizoram, has collaborated with data for the past 5 years with regard to number of candidates appearing for competitive examination, along with the percent of Mizo ST and non-Mizo ST. The said data is set out in a table where herein below for easy reference. Now kindly see year-wise, we made a data, my lord, 2017, kindly see first. Number of candidate in 2017, medical MBBS. It is MBBS, my lord. It was 1566. Lordship got it? All professional courses, my lord. Not only MBBS, we have given list of all the professional courses. Number of geo-ethnic candidates is 1536. That is, my lord, Mizo ST candidate. Now, third column, number of non-geo-ethnic candidate, 38, my lord, non-Mizo ST. Lordship got it? Non-Mizo ST. Now, Chakma candidate is 22. Then percentage of geo-ethnic candidate is 98.1 Mizo ST. Now, percentage of non-geo-ethnic candidate is 98.1. That is Mizo ST. Percentage of non-geo-ethnic candidate is 2.4. That is, my lord, non-Mizo ST. Now, percent of Chakma and candidate is 1.4. This is the data which has been given.
Up to 2021.
Up to 2021, kindly see at page 13, my lord. 2021. Up to the total, kindly see, my lord. Total, if you plus all this, total Mizo candidates is 8993. Kindly see, my lord. 5 years we calculate total number of candidates 9238. Lordship got it? And total number of Mizo candidates 8993. If you plus all these 5 years, now non-Mizo candidates 182. Now Chakma for 5 years it becomes 90, and Mizo candidate is 97.4%, and non-Mizo candidate is 1.97%,
Then Chakma is
and Chakma is 1.01%. So if, my lord, if this data is not being prepared by us, so ultimately what it remains ultimate will be all these seats will be kept vacant. That's why this data was given. But this data was not considered by the learned division bench at the relevant time because of Imbi Channa's case. And that time, when it was decided, my lord, 2018 amendment, the 342A was there. But that was noticed by Devendra Singh. They noticed, the learned judges, 5 judges have noticed that there is a constitutional amendment inserted of 342A.
And statistics state-wise is important.
Then statistics state-wise is important. That can be taken into consideration. So the best part, why your lordship will take into consideration unless it's not been decided by the larger bench. That is why, my lord, the Patna High Court says, sorry, we can't decide it. Let it be decided by the 9 judges, by more larger benches. They will decide the issue. Till then, we will not decide. So on the very first day, my submission, your lordship was not there. A part of the bench, my lord. I told your lordship that, lordship, will keep this particular matter till it is decided by apex court. Because your lordship, with great respect, but how your lordship, it's a difference. Subject matter being the same. I could have appreciated the subject matter was different. The subject matter is same, my lord. Your lordship has seen the classification.
Voter law laid down under 141.
So both law has been laid by the apex court under 141. If Chennai is a 141, Devinder Singh is also 141, my lord. So your lordship is now with great respect is fixed. What we'll do it? So state of my lord, Patna High Court also was fixed when the matter came up. But they said we'll dispose of. Let us wait till the judgment is being passed by the apex court. No alternative, my lord. My lord, I have seen there are certain cases which we move here. And this goes division bench, single bench passed in our favor. The division bench also upheld the order of the single bench. Now the party goes to the apex court. There is no interim order passed by the apex court. Even division bench say, please, we'll wait till the judgment is being passed. There is no interim order passed by the apex court. So, but judicial disciplines are being maintained. Let us wait till the judgment is being passed. So now I will show the judgment which my learned friend has shown.
Para 1 to
I think this is totally a different altogether.
2 was different.
Issue was different. Just
this-
before
I just,
yes.
one query that as per 342A,
Hmm.
your requirement of making a law.
Hmm.
Just come to 342.
Yes.
In terms of 342A,
Yeah.
you need to make an enactment.
This is a rule which we made. 2021 we made the rule.
This is a rule.
This is a rule which we made.
There's a difference.
Yes.
Enactment by the legislature
Yes.
and the rule. Rule under which provision this rule has been made.
Under 309, 309 rules has been framed.
You just read the 342(3).
Not to say anything containing clause 1 and 2. Every state or union territory may, by law, prepare and maintain for his own.
Prepare and maintain.
Yes, for his own purpose, list of social and education. We have a report. We made that report. Because when it came before a division bench on an issue on this, that whether that list has been prepared, socially backward classes, we made a list, my lord.
So this
There was a committee which
first
was.
enactment law has to be there
Yes,
by preparing and maintaining.
yes.
Yes. So there is.
For maintenance and preparation, you have to enact a
So,
law.
my lord,
Then under that law, you can maintain and
why
prepare.
we made a law? Why we made a law in 2002? I'll give a reply, quick reply to what your lordships has made a query to it. My lord, 2021 we made this particular because there was an order passed by division bench. Set aside your 2019, that 2016 rules because you cannot classify it. Ultimate, we have made a statistical data on what basis percentage for last 5 years. On the basis of that data, we changed. In 2021, we amended and made it. We maintained that, and in 2021, we made that.
Only that rule was amended.
Only, my lord, 2000, that rule was amended.
Rule 5.
Rule 5. Only Rule 5 was amended in view of the judgment of the division bench.
Otherwise, the rule is existing from 16.
2016, the rule was existing, my lord.
No, that rule making power, the
Yes.
state has, that is something different,
Yes.
according to us,
Yes.
because it gives you a power to enact a law for preparation and maintenance.
My lord, one second.
To
My lord,
prepare and maintain, you have to enact a law.
suppose,
Then under that law, you will have a power after enacting that law. Only you can maintain and prepare the list of classification, which can be classified, and consequently you can have the rule classification.
suppose I accept what your lordship has said. Now, secondly, going to that means, my lord, my learned friend's argument in respect of the classification that holds no good, my lord. As on date,
Of course, that may have a different.
no, that's the whole crust of the entire issue, my lord. The crust of the issue is this, my lord. We cannot tinker with the presidential order of 1950. So there cannot be any classification. That's what I understand, my lord. That's what my learned friend is advancing, my lord. So, and my learned friend is saying already the judgment is entered by division bench. My lord, kindly see paragraph 33 of Devinder Singh, my lord.
This query is answered.
This, your lordship's query, I think, what my learned friend is saying is answered. Para 33, my lord. Kindly see para 33 of Devinder Singh judgment. 33, page 54 of Devinder Singh judgment, my lord. Lordship got it, my lord. 33. Can I read, my lord?
Just a minute. Yes.
Article 342A has been inserted by the Constitution, 1 Second Amendment, Act 2018, with effect from 14/8/2018. Interest one is the question of reservation of socially and educationally backward classes was involved. Article 342A provisions are parametria with
340.
Articles 341 and 342 dealing with the scheduled castes and scheduled tribes. Under Article 342A, the President is empowered to issue public notification with respect to socially, educationally backward classes, which shall for the Constitution be deemed to be socially and educationally backward classes in relation to the state or union territory, and Parliament may by law has the power to include it or exclude from the central list of socially and educationally backward class. The power of variation can be exercised only once. When we consider definition of socially and educationally backward classes as defined in Article 366, 26C, it means such backward classes are so deemed under Article 342A for the purpose of Constitution. In order to be recognized, it is necessary that socially and educational backward class to find a place in the notification issued under Article 342A(1). The provision of Article 341 and 342 and 342A are perimeteria, and the reservation of socially and educationally backward classes for the subject matter under consideration in the Swami's case. Thus, the question arises, how different opinion can be expressed with respect to scheduled castes, scheduled tribes, and socially and educationally backward classes for the purpose of the classification. The provision of Article 16(4) and Article 342A indicates that it would not be permissible to adopt different criteria for scheduled caste, scheduled tribe, and socially and educational backward classes. The authoritative pronouncement is required with respect to the effect of the aforesaid provision of the Constitution and whether subclassification is permissible only with respect of socially and educationally backward classes covered under Article 342A, read with Article 366(26)(c), and not with respect to scheduled castes and scheduled tribes covered under similar provision, that is under Article 341 and 342, read with Article 366(24), 366(25) respectively. The question of immense public importance arises in view of insertion of Article 342A. When we consider Indra Swami permitting such classification of socially and educationally backward classes, and provisions of Article 341 and 342 and 342A are perimeter, this court is required to have a fresh look on the decision rendered in which and as in the spirit of constitutional provision. Question is required to be re-examined authoritatively by this court, being of immense public importance. Thus, the case is required to be heard by a larger bench than one which decided in which and as.
Precisely.
So this issue has to be decided by a larger bench. That is why it was referred, my lord, all this subject, my lord.
What do you say on the judgment given by the other side?
This judgment is something different, my with great respect, I will say, my lord. Kindly see the judgment referred by my learned friend. Kindly see what was the issue involved. Kindly see the issue involved in paragraph 1. Kindly see what was the issue in paragraph 1.
Yes.
The issue which has been raised in this writ petition is whether an offence which is not compundable under the provision of Criminal Procedure Code referred to as CRP can be quashed in the facts and circumstances of the case. That's the issue, my lord.
See what is referred at 26
Now, kindly see what is referred at page 26, my lord,
to a larger.
to a larger bench. 26, my lord.
That is 16 from bench. That is 16.
Para 16, I think. Your lordship, I think para 16.
Here's a difference. We are having some problem with
Para
the
Para 16, I think, my lord.
Just read it out.
The furthermore,
Furthermore,
16 or 18, I think. Furthermore,
para starts with furthermore.
furthermore,
1 minute.
Furthermore, the issue which has been referred to a larger bench. Furthermore, the issue which has been referred to a larger bench in Gyan Singh case. Furthermore, the issue which has been referred to a larger bench in Gyan Singh case. It's not this judgment, something else is saying, my lord. Reference is on a different subject. The issue involved in the present case was different. So the judge, the honorable judge has said This thing is different altogether. Yes, we'll just tick mark and this. I think page 10, my lord, and it's page 10.
Okay.
Furthermore, the issue which has been referred to a larger bench in Gyan Singh case in relation to the decision of this court in B.H. Joshi case, Nikhil Merchant case, as also deals with a situation which is different from the present case. Lordship got it, my lord?
Yes.
While in the case referred to in here above, the main question whether offence which were not compoundable under section 320 CRPC could be quashed under section 482. In Gyan Singh case, the court was of the view that is a non-compoundable offence could not have been compounded, and the court should not try to take over the function of parliament or the executive. In fact, none of the case referred did this court permit compounding or not compounding offences. On the other hand, upon various factors and concerns, including the futility of continuing with the criminal proceeding, this court ultimately was different. The reference was on different subject altogether.
Issue in the matter was different.
Issue was different. Reference referendum was different. My lord. How can this, my lord, judgment, my learned friend can rely? And your lordship has seen the Patna High Court straight on the point.
Same two judgment.
Same to the two judges, my lord.
No SLP has been filed.
As on date, we checked also, my lord, there is no SLP against that order. And no one will find SLP, my lord. When the five judges, strength is equal of Devinder Singh and E.V. Chennai. Why an SLP will be filed, my lord, when a reference has been made to Chief Justice? Once it is decided, then again they will come back. My lord, last two paragraphs, I don't know, might be different again. What it says, the ratio of the issues.
Same judgment?
Same, which I am reading the Mr. Chaudhary judgment, my lord. That what he relied on. The ratio of the decision in B.H. Joshi case and Nikhil Merchant case, or for that matter, even in Manoj Sharma case, does not help the case of the writ petition. In so and say, the court had in facts of case observed, involve overtouch of civil and so and so. This is not so the instant case where the emphasis is more on a criminal intent of petitioner that on civil aspect views of so and so. So we are inclined to grant the relief. So and so. So that's my submission, my lord. So, my lord, that's what view of the Devinder Singh judgment. I'll rest my argument with saying that lordship should wait till the judgment is passed by the apex court. See, and follow also Patna High Court. That's my learned friend answers. And so far as 2020, then my learned friend said that he came once in the High Court and there was an order. It was completely, if your lordship calls that, that was completely, I appeared in that. They came very late in the month of January. After admission was over. And they relied on some all India quota, some examination. So there was some interim order. Then we clarified the court that no, that's not a situation. Admission was over. So they never praised the contempt, my lord. So now they got admission in pursuant to court's order. We, my lord, there is some system which we applied because ultimately it has to be this. The admission takes place by the government of India. It has to be referred to them only. Well, there is a portal. Which portal? They can only open that portal. Ultimately, it has been done, and ultimately admission has taken place in view of the court's order, my lord.
Portal is open and close also.
Portal open and close. Further, now if you again want to open it, my lord, there are some orders to be passed. Then again we have to write to them. Again we have to write to them, my lord. Why it got delayed? We wrote to the government. There is a portal which they opened and they say there is an order passed by the court. Please comply. We complied that order, my lord. That's my submission. A very quick reply what my learned friend has said. My lord, that's what my learned friend structured the entire writ petition, the PIL as writ petition, and the query that has been put. And my learned friend relied on the judgment of a division bench. There cannot be classification, my lord, and which I said that there can be a classification in Devinder Singh case, and Devinder Singh case holds good as on date because that's all the case under 141. E.V. Chennai is only 141. So Devinder Singh, what it takes the constitutional amendment into consideration. So my learned friend relies on that can be classification. No classification. So that's the entire thrust of the entire case. That's my submission.